Everything has been discussed. And lastly, order was passed on 12th of April 2023 on page 19, last paragraph. Now, in compliance of the solemn order of the High Court, Calcutta, dated. Oh, sorry. And he has got separate cause of action because of this order passed by the Supreme Court. A order may be good or bad, that is up to your lordship. That will be decided by the appropriate authority.
What was the initial order?
Yes.
My lord, your lordship set aside the order and directed the Despot number 3 to consider the matter pursuant to my lord directions.
Taking into account that the resignation letter which has been submitted by the petitioner to be as on date, number one, and
that should be taken as on that.
as on date, that date, and they cannot resort to the embargo of 5 years.
Yes. So
Now, my lord, they were
taken an embargo of 5 years.
yes, they have again done so.
My lord, kindly see order.
It was
And my lord, subsequent.
The Despot number 3 is directed to.
whether the rule has not been issued.
My lord,
Yes.
kindly see the page 19.
Now, my lord, there were two matters. There were two matters. In one matter, your lordship was pleased to pass an order for directing to issue rule. And this is the second matter where they had
That is,
filed.
I remember.
Yes,
My
yes.
memory has not betrayed me as of now. Mr. Mukherjee appeared
Yes, yes.
and we did not accept the explanation which was so
Yes.
offered.
Yes, my lord.
He dictated the,
Yes, that is the order. It is the
then issued a rule.
yes, my lord. And that is this is that order.
The same thing which has happened.
Yes, my lord. Here also.
Show us that they had taken a same plea of 5 years.
Yes.
My lord, kindly see the order passed by
Please.
page 18, starts at page 18 of my affidavit of opposition.
Just show us that he has taken a plea of 5 years. Just show.
In pursuance of the order passed by the High Court, Calcutta, page 19, third paragraph, the undersigned, the Despot number 3 Director of Education put forward the observation through
That
the
was there, that this is not a
has
continuous
not
one,
completed
5 years.
but actually performed this
Page
continuous
4,
public
paragraph 9.
service for
That was
4 years,
also
9
taken
months.
in that, towards that order.
4 years, 9 months, 3 days.
What
From
is
the-
a sauce for a gander is a sauce for a goose, because in that 2 years something, and then it's saying absence,
Yes.
but they did not take any step.
But kindly see 4 years, 9 months, and disciplinary proceedings says a charge sheet has been issued. And 17 July, disciplinary proceeding has been initiated. When disciplinary proceeding is initiated, charge sheet has
After
been
the-
issued. After that, remand could be released.
After your lordship's order, they have initiated a departmental proceedings, taking again the plea of unauthorized absence, again resorting back to the 26th Augustus memo of 5 years. And my
No.
lord, in my reply to such, I have categorically stated, kindly comes, my lord, to page 29 of
When
their
a disciplinary
affidavit
proceeding has been initiated, nobody can be released under the service response.
subsequent to the passing of your lordship's order. Now
And
they have come.
charge sheet
And
has-
I have
under-
stated,
The innovative child of Mr. Mukherjee's advice.
No. I am a small man. I have nothing. Although I am representing the government, but I am not the government. There are executives are there.
Never said, I say it's an innovative advice of Mr. Mukherjee which is being implemented by the executives.
and my lord, I had
Not
categorically
said
stated,
anything else.
But a department, when government has taken a decision to initiate disciplinary proceeding, charge sheet has been issued. Can one be released from the duty?
Was after the order of this court.
yes, my
But a suspension order was passed on, 10th of July 2023. No, kindly see retrospective here. Kindly see the page 22.
10th
The
of July.
governor proposes to hold an inquiry under Rule 10 of the West Bengal Services Classification Control Act of 1971 against Dr. Devashish Mukherjee as to
Mr. Dhar, we need your assistance because we wanted to close this kind of a issue. What is happening is that the health sector of the government department, the doctors have been, the medical practitioners, they are engaged. They are rendering services Now everybody aspires for a future better prospect. This is a very common notion of the human nature. Nobody can come in the way. They got the better of us.
Not only human, all species. The monkey in the forest
The
wants to be a
migration
leader also.
is also one of the
Yes, yes, yes.
for better.
It's a feature. All species.
What has happened? They got the chance in a better sector, means the main health sector in some other place. They tender resignation without claiming any kind of an equity under the rules. They simply tender resignation. I want to go.
Yes.
Please relieve me. I want to go. I will not claim any past services. I will not claim any kind of equity. Nothing.
Yes.
The government says I will not accept your resignation. We have been very critical in some of the cases. We say you can't force a particular employee who is unwilling
Yes.
to work. You can't.
Yes.
Because you cannot extract the good potential therefrom. That was thing which was going.
Correct.
They have cited some rule on the government notification which says that 5 years is the locking period. You cannot. I do not know. We have not gone. When the matter came, because the before us, then at that point of time we find that the 5 years has also elapsed. So
So,
they say no difficulty. Now you take a decision. Now 5 years has gone.
yes.
Treat this application to have been made on the date when the order is passed,
Yes.
which must be treated after 5 years.
Yes.
Decided. The moment they realized that they can't do it, immediately they took a stand. Since you rendered 4 years, 9 months, 11 days service,
Yes.
which is short for all of, and you did not thereafter join because writ petition came in the meantime. So you have not done the continuous service of 5 years, and therefore your application is premature rejected.
Yes.
I wanted on this score, I wanted your assistance that whether these kind of a it's a kind of a malice. It's a kind of a thing that I do not.
But I have a word for it.
Questions.
Well, we should never rationalize when you know this is wrong. This is the rationalization of something which is wrong.
I can't find out a single word for it. I could not find out a single word. But a malafide may be to some extent because it's a malafide approach which they have. We wanted to set a precedence for that. So they have come as a amicus curiae. We wanted you to assist the court.
I was just, it was very relevant. I was having a talk with my learned junior. I was simply saying this. It is for Mr. Mukherjee. I said that I appeared for the respondents also, many of the contempt matters. And there are so many matters. I remember the very first day when I found that something wrong is there. I think I'm not.
I think you should not reject this.
I'm not. There has to be. There has to be.
Do not invite any comment from.
No, I'm not. I'm not. I'm not. A lot of problems can be solved. I understand.
Because you know my genetic defect. If
Defect.
you invite me,
No, DJ. It is a privilege. It is a privilege.
Submissions will come, which I do not want.
No, but I don't get a genetic defect. It is a privilege.
Despite the order passed by this bench, directing the concerned authority to treat the application for resignation to have been filed on the date of the order disposing of the mandamus appeal, the authority have still banked upon the executive orders and interpreting in a way that the 5 years period has not elapsed. Though such attempt is apparent and evident from the stand of the authorities, for the simple reason, once the court expressly observed that the letter of resignation should be treated to have been filed on the date of the order, comma, it is not open to the authorities to take a shelter that since he did not render a continuous service of 5 years, he cannot be regarded to have completed 5 years. We would have safely proceed to issue a rule, but we wanted to set at rest the stand which we found to have been taken in several other contempt applications. In the instant case, a disciplinary proceeding appears to have been initiated after the contempt application is filed. Contempt application is filed or before?
No, 10th July 2023.
The order was passed on 1st of March.
After the order disposing of the mandamus.
Madam, mandamus bill, tribunal application.
Sorry, tribunal application. Tribunal application. No, writ petition.
Writ petition.
Writ petition. Which should also be taken on record, which should also be taken into consideration. Whether the same can be construed as a malafide action to thwart or frustrate the order of the court, and may be regarded as a contemptuous act. In order to have, we therefore invited Mr. Pratik. Are you writing Kumar or no?
No.
Mr. Pratik
I have never written. So
Mr.
I never
Pratik
lost
Dhar,
my
senior
Kumarship.
Pratik Dhar.
to assist the court as amicus query. When can we fix? All of you tell us. Because I know him, he will take little time. To tell me. Because Mr. Mukherjee was so busy, that's why I wanted
Yes.
to.
14th February? 14th February? Friday?
Very auspicious day. I mean,
Eh?
14th February is a
Ordinary
very
ticket
auspicious
Friday.
day.
14th February.
Yes.
14th February is Friday.
Not under the Hindu mythology. And
Yes, true. We are saying something different.
he has crossed that particular.
I don't think, because he has a mobile, he possibly is on social media, so he shouldn't. But because of the pressure of many matters,
He has crossed the age.
well, that
No, I should not come to the court. That is the
No.
again you are
you
coming
must.
in a canteen. You are coming.
There is no age for that. For thought, at least there is no age.
Oh.
I clarified.
14?
Well, the affidavit.
Affidavit?
Exception.
Reply by the give him some
Yeah, I will take it.
orders.
I
Give
shall
him some
hand it.
orders.
Well, I
Mr.
shall.
Mukherjee also you give them.
I shall hand over. There are two applications.
You know.
Well, there are two applications. I shall hand over the entire set of documents of both the applications.
Just it. My office will scan it and return it to you. No.
Scan and send.
No, you don't.
এইটা বাড়িতে যাবে আমার।
Yes, that's it.
Give it to him in the
এইটা আলাদা করে যাবে। আগে।
all the things.
Item number 216 and 17.
17 তুই?
No, I believe Mr. Dhar is to reply today. Mr. Ray has completed his submissions. He only asked me to add one thing, my lord. though he has made that submission at the cost of repetition,
Government Ray,
Mr. Anirban Rai had made submissions on
government pleader,
Yes,
the government pleader.
he completed.
Mr. Ray, then I.
Well, I'm sorry.
Mr. Pramit Ray was arguing,
Yes.
so I just thought
Then-
that.
Well, though he has concluded his submissions, only one thing to be added, which he has already made submissions, that since it was a matter of interpretation as far as we are concerned, my lord, if your lordship feels that someone is to be reverted back to the earlier post or demoted, we'll do that, my lord, but there is no intention to, my lord, be extra affectionate towards someone or be in contempt of your lordship's order. There were, according to us, there were two interpretations. We have gone by one interpretation, and
Understand, this is really the
Yes,
merger
yes,
of
yes.
the two cadre into one, and then putting somebody to a higher position.
yes, yes.
And then he argues that since the qualifying period is provided and he is the only person who could justify the qualifying period, that's why he has been considered, and they may be put into one or two position, but they do not.
They have
qualify.
already been put in 1 and 2. Already been put
They are not eligible for the promotional
to
post.
the executive engineer because that qualifying service is not.
3 years or a 4 years.
6 years of qualifying service is not there. And there cannot, we believe that there cannot be any deemed experience in the post. That was our interpretation, but my lord, the intention is not to be in contempt of your lordship's order. If someone is to be reverted back, we'll revert them back.
But experience is never used in the statute. This is what the London
Lordships.
government leader wanted to infuse into it by virtue of a legal fiction. That's something which may not be apparently there, but it was always an intention to bring within it.
Rules to then a note to na diye.
My lord, in fact,
And my lord, for your, if required, my lord, though it has not been called for, if required, we have also, my lord, prepared a written notes if required. If called for by the honorable court,
Never prevented anybody from filing a written notes because we are of, I have particularly me, I can say of a strong view that if the points are argued,
yes,
that must be reflected in the judgment.
but if required, my lord,
Not required. If you have prepared it, give it.
I have brought one. My lord, on the last night, there was, I can use the word, an interesting discovery in this matter, which may put all end of their entire submissions. In fact, I missed that also. I think all of us missed it. And that happened while I zoomed in
When you zoomed in,
a particular page. I just want to place it, and I think Lordship will, but before placing, just because Lordship remembers everything,
preludes.
just that it was London government pleader submissions that while sending it to the PSC, we showed the private respondent and number 1 because of following a separate rule which requires 6 years, and I didn't have 6 years. So it's a matter of interpretation. Well, and now PSC was honest enough to annex a document of their proposal. I zoomed in what exactly they followed there. And there I discovered, which I did not, I missed the earlier occasions. Kindly take, my lord, page 25 of the PSC affidavit. I think that is the end of everything. In my understanding, after this, they may not have any options other than apology.
You are
Contempt number 6.
6.
PSC.
Give it a husband. That was 6. Yes. Barkurida. Please 25.
Page 25.
Black mark.
Yes. I placed it, but while I placed it only to show what was done wrongly, but I did not zoomed in on that time. Lordship has taken page 25.
You are talking about the notification date.
I am talking about, kindly, well, may I say thereafter, everything would be clear. But I was on the understanding their whole argument was page 25 could not have been, my earlier submission was page 25 could not have been sent because there was a subsisting interim order. Page 25 equals to ignoring Note 3, Rule 4. Complying the tribunal's order. And that was done in clear violations. Only I stopped there. But they said, no, even then we sent it because we followed a rule of 1994. Well, that 1994, Lordship, I can take note what Mr. Learned Government Pleader relied on, page 27 of their opposition. Lordship, kindly have a look. First take opposition by the state contemners.
Yes, 1, 2, 3, 4, and 7.
Yes, yes. Kindly take page 27. Kindly take the notification number and the date. Just take the date, 21st of November, 1994. So therefore, as a matter of
24th of December 10, 1994.
Lordship is at
Oh,
page
sorry, 21st November.
November 1994.
Correct.
So argument was made that there is a requirement under this 1994 of 6 years for promotions. You did not have that experience, no matter that you were there since 2000, based on Lordship's judgment. So that's the reason we send it to the PSC. Now kindly come to 25. Now, may I read it? The annexure to such an engineer who are eligible for promotion to the post of executive engineer under PhD department names, kindly this is portion, names arranged as per principle, top, extreme top, this
Seniority less.
Lordship, above the table, this is above the table.
Seniority less
Authority list of assistant
of the assistant
Yeah,
engineer.
right. Who are eligible for promotion to the post of executive engineer under
That is as per
principal laid down in finance department.
81.
Yes. Now,
About 81
and that 81,
does not contain.
no, that 81, kindly come to page 69 of contempt. That was the rule Lordship interpreted. This is a complete afterthought.
Where?
Kindly come to page 69. Note. This note is there in 81,
Page?
69 of the contempt application.
Yes.
Kindly take the last paragraph.
It is not in dispute.
Yes. So both the contest, this is the rule of 1981, 11th March 81. There contains the rule 4.
Which contains rule 4.
Yes. So therefore, firstly, they could not have sent it because of the stay and the status quo. Secondly, they misled the PSC by page 25 by saying that this is as per the principle of 1981 seniority rules.
And what about this 94?
94 was never, 94 is it's a lawyer's idea. It's an afterthought. 94,
21st November
well,
1994.
my point is simple this. 94 is a rule that was never even looked into by them. They did not send as per 94. That's the document at 25. It was sent on the basis of the 1981. Yes. What else? Today we are in contempt. And that, now this, he comes at number 1. And Lordship's judgment is to be followed. Then page 110 of the contempt application. This is the effect of correct interpretation of 81 rule.
Yes.
gradation.
So, determination of here also they talked about 1981 rules.
Yes, kindly look at this is post Lordship's judgment.
Yes.
So there, Lordship, kindly look now what they have done. This is something, it's so. Lordship judgment was of 1st of February 23.
I understand. But I just wanted to know
Yes.
that this seniority rules, because it is a determination of a seniority rules of 81.
Yes.
And this 81 contains the note 3,
Yes.
whatever,
That was the subject matter.
that was the subject matter we
Yes.
interpreted.
Yes.
And now as per the note 3,
Yes,
they have to say that in terms of this rule,
yes.
the note 3, we have to follow and then we have.
And they have done so.
we
Page
have-
110, they have done, and therefore I come at number 1. Kindly see from first of,
Show me a 81 rules which requires a 6 years period.
it doesn't. That's what I'm saying.
Where is
60.
81?
All I'm trying to say this, that the contemners in pendency and subsistence of a
And perhaps argue this is recorded in internal page 12 of your lordship.
No, I understand. We have argued 81 was the consideration before us.
94 was also faced by my lordship.
94. Well, may I say this? May I say this?
No.
Question is not
No,
placing.
does
I
not
might.
contain the
Perhaps
note
I'm
3 or
failing
rule
to
3 or
understand.
rule 4.
Yes.
But the 94 is relatable something else. I just wanted to know one thing.
Correct.
That 81 contains any kind of a condition. that
How seniority to be maintained?
6 years,
No,
period is
no, no,
mandatory?
no, no, no,
6 years. I just
No.
wanted to know. that.
no,
And just explain that. Let Mr. Bras finish, well, I'll explain that.
Yes,
no. Firstly, no.
mentioned in page
Secondly,
22.
secondly, my point is different.
22.
Today, you are trying to give an impression that we have sent page 25 on the principles of 94. Firstly, you could not have sent it because of the stay order. Secondly, you sent it. So what PSC is getting the impression? PSC is getting the impression that page 25 has been prepared following the principles of 81.
That is what is reflected also.
Yes. And if 81 has to be followed, the correct is 110. I should come at number 1.
Can you let us come and can you show me that 81 rules?
Yes, Malad, that is there at page 85 of the writ petition.
Just show us the 81.
Kindly take the, because it might be marked by your lordships, writ petition. That was initially, but it is post discovery of. My lord, what I was trying to, may I just, my lord, before what I was trying to submit this, that admittedly tribunal's order from the day one was stayed with an order of status quo, admittedly. And that it was till the delivery of the judgment. There is no dispute on that. So admittedly during this process, they could not have sent any proposal for anybody. The reason is why? Because if they send the proposal, there are two choices. Either to follow this note or not to follow. Tribunal said, don't follow. Lordship's final judgment?
Follow.
Yes, follow. During this time, they can't do anything. Now, this is the context. Now, in this context, the PSC filed their affidavit, said that in August 22, we received this proposal from the state contemners. I could have understood the bona fide that it is coming from the state there. State has never disclosed what is the date they have promoted the private respondent. They have not disclosed. The documents have come from the PSC affidavit. And the PSC affidavit shows two extremely important things. First, page number 18 of the PSC affidavit. Or Lordship can take page 24 itself, not page 24. Because it is the authority is the PSC. PSC has to check. PST has to see whether it is in following the principles of 81.
The answer to this was that you have not come up alleging the contemptuous act having committed on the tip of an interim order in the mandamus appeal.
Yes.
So that is what they say that cannot be looked into because
I have a clear-cut answer to that. The crux of your judgments of your lordships, if I say 2 points. Number one, the note 3 rule 4 is applicable and inter
that may not be in a strict sensu, it will invite a contemptuous act. But the act which is done on the tip of an injunction, and ultimately when the court has set aside the order of the tribunal,
Yes.
then at least they should have revised and should have sent the revised list.
Yes. But I could have understood, correct. I could have understood that. I could have,
They should have withdrawn that.
yes. I could have understood that. That PSC takes a decision that because I have a lack of experience of 6 months, therefore we don't recommend. But PSC gets to know not about me because of page 25. PSC gets to know page 25 equals to correct interpretation of 81.
Where is 81?
Yes. 81, Lordship wants to see the pages that Lordship saw, or I have a fresh copy of the 81 rule also. The copies are there, or if Lordship wants to see repetition, it's page 85.
It will be handy for us.
Yes. The second page. The note 3. It is relevant to rule 4. Insofar as the determination of relative seniority of persons selected either by the commission or by others.
Just looking at the 6 years barrier,
No,
it does not contain.
no, it does not. Neither it is a
6-year barrier comes.
is an afterthought.
It is only under 1994.
It is under 1994. Now that
You have referred.
yes, and Lordship may kindly look at page 110, the effect. Effect is that I became senior from 1st of December 2000.
Because this was revised and it was.
Yes, yes,
So they wanted
yes.
to take shelter under the experience.
yes. Now, experience part, Lordship has seen the difference between the word experience for the direct recruitment, via in service.
That is what we.
Yes,
Pointed out. to
yes.
them.
Well, otherwise,
There is a, you just showed it to me, 94, this.
yes, well, that is in the state's affidavit,
affidavit.
page 27. It starts, the relevant portion is 28. I could have understood the bona fide that the state, sorry, page 27,
Yes. This is for executive.
next page, page 28 is for the executive engineer. Lordship will see the qualification for direct recruitment, Roman 2, 6 years experience. The word is experience. Well, this was first time observed by your Lordship. And then kindly come to 2, notwithstanding anything,
years of the post
6 years in operation. Here it is,
completed.
yes,
6 years of.
service as assistant engineer. That's all. And past examination, that is, it has been amendment. Post 50 years is no examination. That is there. So that part neither they said nor I have to say. So both of them are post 50. I have that amendment also. It is with the contempt applications. Madam, I am trying to submit this. I could have understood some part of the bona fide. Yes, you did violate. But today, their interpretations or their justification for the violations can be understood that at least you have told to the PSC that we have made Sudeep Shah at number 1 on the basis of 94, which is your submission. But they made Sudeep Shah as number 1, not on the basis of 94, clear from page 25, by actually going in accordance with the tribunal's order, or if I can use the word, the way they wanted it to be done. So therefore, for the purpose of contempt, I say this is an afterthought. Page 25, and Lordship may kindly have a look, the affidavit of the PSC, page 8, first paragraph. The same affidavit. Sorry, page 7, first paragraph. So dates are also provided by the PSC. So this is the date falling within the subsistence of the interim order. And that is the reason, page 24 of the same affidavit, they had to state an incorrect statement. Kindly take page 24, serial number 18. They had to say no existence. And page 117 of the contempt application. Now, this is, they are showing, yes. Kindly see, my lord, page 117. This is now in April 23. They are showing that we are promoting private respondent, but they are not mentioning on the basis of what document. When did you send it? Is it on the basis of the principle laid down by your lordship post the judgment? Page 117 is the promotion. PSC disclosed it, that this was on the basis of page 25 of the PSC affidavit. So the deliberate act is to keep everything in an obscure situation. And in the affidavit, lordship, this is it goes in sync that state in their affidavit. I could have understood that if you are fair enough, you should say This is the date. I have sent it on the basis of 94.
They were silent about this.
Page
particular-
12 in their affidavit of the state contemners, first paragraph. They simply did not say the date because they can't say it. Kindly take page 12, first paragraph, state affidavit. Page, my lord, this is by the state.
Clause.
My lord, this is just above the clause F.
That's none of the applicant.
My lord, the sentence start with then 6 years of service as assistant engineer. Second sentence, Mr. Sudip Shaha, lordship is at page 12.
Yes.
This is the sentence starts with what word?
No, it starts from page 11.
It starts from page 11. Page 11, well, page 11, last paragraph E. It is evident. It is evident.
Born in the cadre of the such and such upon being promoted to the post of such and such in 2000.
And upon completion of more than 6 years of service as assistant engineer,
He's
Miss-
promoted to the post of executive engineer.
when? His illegality happened in 11 plus 6, 7.
Yes.
So what they say before your lordships on affidavit, absence of the date when they sent it to the PSC. I can understand, no difficulty, take these interpretations. But if your interpretation is 1994, if you bank that Sudeep comes at number 1 on the basis of 1994, then you say so in your proposal before the PSC. Let the PSC take a call. They don't do so. Before PSC, they first suppressed. There is no order. There is no pendency of the case. And this is the list where he comes as number 1 following 81 when Lordship is dealing with the case with a stay and status quo. That's a, if Lordship kindly take my this. So first, Mela, that's what I have just submitted. That this clearly shows that the state contemners made Sudeep Shah as number 1 on the basis of, I have quoted, principal let down in finance. This is dated 81. This notification is the very same rule, namely such and such. On page 69, their lordships recorded, quoted, and that was the entirety of the entire matter. Therefore, 25, PSCO clearly disclosed that Sudeep Shah was not shown as number 1 as per 1994. But the next bullet, therefore, page 25 of PSCO clearly disproves the contention of the state contemners that Sudeep Shah was ranked number 1 based on the notification dated 21/11/1994 as submitted by the learned counsel. In fact, if they had not said so, the PSC would have stopped there. Well, a third bullet point, next page.
Yes, had they disclosed it?
Yes.
They misplaced, they
Yes.
misled the.
Yes, the state containers even misled the PSC into believing that the recommendation was made under the West Bengal Service Determination Seniority 81. Notably, the learned tribunal had directed the exclusion of Note 3, Rule 4, a direction subsequently set aside by the Honorable Division Bench. Everything is disguise. Furthermore, at 24, serial number 18, PSC's opposition, the state contemners falsely claimed that no case were pending and that no interim order existed. Third, following the Honorable Division Bench judgment dated 1st of February 23, the petitioners were ranked as number 1 and number 2. Now, effective from December 2000, that's the bone of contention. In fact, we were put number 1 by them also because of the several 5-6 litigations this happened. Page 110. However, the revised gradation list reflecting this position, that too with effect from December 2000, was not forwarded to the PSC when seeking recommendation from promotioner Sudeep Shah. The PSC in its AO clearly admitted this. Well, I have given their admission. Page 6, first para. The state contemners deliberately did not disclose when the promotional recommendation for Sudeep Shah was forwarded to PSC. But that's page 12 I've just placed. Due to interim order dated, yes, due to interim order dated 29/19, yes, the state contemner promoted Sudeep Shah by acting on the basis of the learned tribunal's order.
What your contention?
Yes. And is recorded, and lastly, my lord, the state controls actions demonstrate a clear, willful and deliberate violation of both the interim order and the final judgment and order dated such and such. This violation include suppression of crucial facts. These are my responses.
My lord, generally, I'm not in the habit of a reply to reply, my lord.
For reply, what?
Well, I know that I'm not in the habit of a reply to reply. my
The
lord. I'm
notes,
te-
Malad,
My lord, just a minute, Mr. Bondavanda. My lord, may I just have 1 minute of your lordship's time, my lord? My lord, I will just take your lordship, just keeps a note of page 22 of the affidavit of PSC.
Yes.
My lord, Mr. Bondavanda has already said that we are here, my lord, whatever your lordship passes the order, we are ready to comply. But kindly sees what Mr. Thought just now said, my lord, maybe he is not properly instructed, my lord. Kindly take page 22, this is the forwarding letter, which talks about, my lord, that 6 years of service and the recruitment rules were also forwarded, my lord. Just for the part of bona fide, and my lord, if your lordship kindly sees the recording which he has said, my lord, in that page 25, my lord, but it talks about seniority list of assistant engineers who are eligible. The eligibility was under the 1994 rules, my lord.
Yes,
If-
that you have
Yes,
argued.
so my lord,
that will
there was no
consider.
suppression of this, what Mr. Dhar has said, my lord. I just wanted to point that out, my lord, with humility, my lord. That was there in the letter of 20 at page 22, my lord,
Yes.
which under which that was sent, my lord.
Yes.
And other than that, my lord, I leave it to your lordship, my lord. It was a case, my lord. I tender my apology. Maybe, my lord, it was a wrong interpretation. If your lordship feels that, my lord, kindly, whatever your lordship's orders, my lord, we are ready to comply.
Yes. What about, I don't think so. Mr. Saha,
May I make a very short submission?
what, Mr. Saha, what you will say? You are representing Mr. Saha. What do you say?
Two, three
It is-
sentences
My lord,
only.
maybe put on note,
You are,
if your
you are
lordship wants, my lord.
if it is found that there has been something which is beyond or contrary to the order of the court.
Milord, I
you
try to
can't
demonstrate
defend
that
your- Right,
Milord, I'll try to demonstrate that is not contrary to Milord what law Milord perceives.
yes.
Milord, firstly, Milord, there is no Milord need of saying that Milord, if an order is Milord capable of interpretation of Milord two.
No difficulty.
Yes,
Says
that's-
that it cannot.
that number one. Number two, on last day, Milords were Milord drawing. Milord, if I have Milord understood correctly, Milord, a line of distinction between Milord experience and Milord service. Because Milords were of the view that Milord, one rule provides Milord for experience, one rule provides for service. So Milord,
Same post.
yes. So Milord, these two expressions cannot be Milord used interchangeably. Milord, that's what was Milord possibly passing through Milord's mind.
That is the ordinary rule of interpretation. If for same post, the eligibility criteria is different, then the legislatures are conscious that the criteria which is put for one category of the candidates will not be imputed or borrowed in the second category.
Milord, the rule of interpretation, Milord, of an act and a
What is
rule.
there? Otherwise, the legislature could have incorporated.
But the rule of interpretation of Milord an act and a rule is possibly Milord slightly different. Be that Milord as it may, Milord, we cannot Milord read a rule as strict as we Milord read Milord a statute, Milord an act.
Rule is not a.
It's statutory,
Then
statutory, no doubt of
talking
it,
about.
no doubt of it. But
Only
Milord,
thing is we cannot read the judgment of the court as a
that's true,
statute.
Milord, that goes without saying. But
No,
Milord,
no,
act and rule also Milord to be read, Milord, possibly Milord in a different way. Milord, I am not getting into that. Milord, the rule says that Milord service, with 6 years of service or Milord 12 years of service, whatever. Milord, whether this service Milord also takes within Milord its umbrage, Milord notional
If the
service.
experience at the post, we'll consider it.
Milord,
Consider
two
it, what
decisions
more?
only Milord kindly allow us to rely.
They have
That Milord,
cited
when
much.
Milord it comes to qualifying service, Milord, this is qualifying service, Milord, not experience, qualifying service. Qualifying service
I
means
think the word qualifying is also not there.
Milord, that is to be read into, Milord, that is to be read
It is
into.
to be read within the
Yes,
lines.
Milord, otherwise Milord, it does not have a meaning at all. So Milord, if service is Milord, what is Milord contemplated? Milord for getting promotion from one post to the other and service in the feeder post for a Milord limit, Milord, minimum period of time, Milord, that's a qualifying service. And qualifying service, Milord, can never be notional.
This is, my lord, no doubt a qualifying service in the feeder post, and that can never be notional.
You are free to argue anything. We can't stop you. Show us the judge.
My lord, one is, my lord, of Chandigarh High Court, my lord, division bench. My lord,
You did
kindly
not
have a,
find any judgment of this court or a Supreme Court.
my lord, because of my, my lord, limited experience, I did not.
You are traveling to near about more than 1,000 kilometers from the principal.
But,
seat.
my lord, again, my lord, a judgment of a division bench has a, my lord, pan-India implication.
Whatever. It may have a persuasive value, not binding on us.
But, my lord, a pan-India implication, that's what, my lord, Supreme Court said. My lord, we have learnt it from your
It's a
lordships only.
persuasive value, not
True. My lord, kindly take, my lord, paragraphs 15, 16, 17. Oh, হ্যাঁ দাদা 16 SCC online পাঞ্জাব হরিয়ানা 5542 আর তোরটা দে পাঞ্জাব হরিয়ানা 5542
I can give you a latest judgment even thereafter of a Supreme Court relating to our judicial officer's case.
means on this qualifying service.
This is on the basis of this ad hoc services. When a judicial officer who is at the post of civil judge senior division is posted at the fast track court judge,
Already remains in the parent
he is
cadre,
discharging the duties of the additional district judge.
but remains in the cadre of military.
He is still getting the salary of the additional district judge,
True.
my brother will say, but he remains in a cadre of a civil judge senior
Senior
division.
division. But
And
that is
therefore-
something different.
And
possibly.
so ad hoc appointees cannot claim. And then there was a judgment, they claimed before the Supreme Court that since they were discharging the functions of a district judge, they were getting the salary as that of a the additional district judge. So the period which they rendered for this fast track court, that should also be counted, qualifying for the purpose of gradation, which was turned down by the Supreme.
No, that was because of the scheme of the fast track court,
No,
possibly because
no,
the scheme
fast
is
track court-
temporary.
No, the scheme was not such. It was not such.
Millard, we had the Millard privilege to do a
Because
matter.
in our High Court, so far as Calcutta High Court is concerned, there is a separate promotional examination for the civil judge senior division to be promoted to the post of a fast track court. You know, it's
Mhm.
not that just they are put to discharge the duties on the basis of the seniority. No.
It's Millard merit cum seniority.
The artificial creation of a post in between the civil judge senior division and the ADG, district
True.
judge entry level.
But Millard, that was not the case, Millard, in the reported decision.
This is what a case it says.
Kindly take Millard.
Opinion.
Yes.
The promotion shall be counted for a regular service. This is what it says.
It says, Millard, where the question as to whether the period of notional promotion shall be counted for computing regular service has arisen for determination. Then, Millard, that is answered in paragraph 17. Says that at any rate, inasmuch as actual regular service of 12 years to get the benefit of lateral advancement scheme floated by the respondents has been insisted upon under Annexure P5, the period of notional promotion given to the writ petitioners at the intervention of the court, like here, Millard, in our case, cannot at all be counted for the purpose of conferring benefit under the lateral advancement scheme. So, Millard, what is notional remains notional, and Millard, this does not fulfill, Millard, the qualifying service. Millard, one more, Millard, of Madras.
You have traveled more.
Millard, to show that Millard is pan-India, Millard, there is no quarrel, Millard, with the proposition.
Not to an extreme south.
Only to show that, Millard, all India basis, this is the law.
From north to south.
Yes, Millard. Without, Millard, a difference of opinion. হ্যাঁ দাদা 17 SCC online Madras 22271. Millard, paragraphs 4, 5 and 6. On the same proposition. This will qualifying service. If qualifying service will not notional promotion, notional appointment, Milord, don't do. He has to, Milord, actually. I'm sorry. Yeah, 14 বার দেখেছি। হ্যাঁ। ওটা দরকার পড়ছে বলে মনে হচ্ছে না। If you insist, Milord.
Anyhow.
Now, Milord, kindly just have a look at the rules once more, Milord, if my lords, Milord.
Yes, sir. They have already seen that.
Kindly take, Milord, the rules, Milord, rule 4 once.
আমাদের affidavit page
Okay, Joshua শুনছি।
Inside top page for executive
Milord, if we start, Milord, reading from rule 4, Milord, from the starting of,
engineer.
correct, not about.
But the second paragraph
Yes.
is executive engineer.
Correct.
No difficulty. They have read it.
My lord knows these provisions, Milord, by heart now. Milord,
Now,
after that,
we gone into it and we put a lot of questions on that.
true. Now, Milord, then coming to, Milord, this non-obstante clause, Milord, there is a difference, my lord has seen that between, Milord, the proviso to, Milord, superintending engineer provision and then, Milord, this non-obstante provision. It says, notwithstanding anything contained in any other rules of assistant engineers shall be eligible for promotion to the rank of executive engineers after he has completed 6 years of service as assistant engineer. Milord, this cannot be anything but, Milord, qualifying service.
This is a special rule. 81 is a general rule.
And Milord, this is, Milord, a special rule, Milord, for the, Milord, assistant engineers for promotion to executive engineers, unlike, Milord, 81, which is, Milord, a general provision. These are, Milord. And Milord, so far as contempt is concerned, Milord, contempt does not. That does not.
Why you have been roped in the contempt, I do not know. Why you came in the contempt, I do not know. You are not in contempt because you are the beneficiary of the contemptuous act.
Of, Milord, the provisions of law. Beneficiaries of the provisions of law.
Alleged
Alleged,
contemptuous
Milord, contemptuous act. And Milord, 2 posts are still there.
Rephrase the word. Alleged contemptuous act.
And Milord, 2 posts are still there, where Milord, Mr. Dhar had, Milord, submitted that, Milord, he is agreeable. He do not want to, Milord, does not want to run after me. Milord, he is agreeable if he is accommodated in those posts.
The state is not.
Yeah, this is, Milord, my submissions. I, Milord, should not be touched.
It becomes adamant.
State is not.
I, Milord, cannot be
because-
touched.
because they're sticking on.
Milord, in a contempt application, Milord, if a third person is, Milord, touched upon, and Milord, he's,
What are you talking about? It's a contentious act. If the consequences is there, it has to be there. You can't get a benefit. Any person who is getting a benefit or usurping or may I say the fruits of the contemptuous act.
provided with the
Can
contempt
have
is, Milord, on the face of it,
right.
Milord, is an act
I
of
do not
contempt.
know.
Very.
So
Milord,
who
these are,
can
Milord,
have the protected right.
Milord, these are, Milord, my humble submissions. Great.
I don't know why you made them a party in the contempt.
So that we can
To
have.
ensure that, Milord, we have a camaraderie.
To his presence. For the present fraternity.
But I often say this, this said, the whole existence of the respondents is only when there is a petitioner.
Correct.
So I would be happy to see Mr. Banerjee and be there, contribute some legal aspect of it.
And receive.
That part,
Receive, Milord, review from the honorable bench.
this is nothing to do with the cases.
Can't be made a party in a contempt.
Grateful to your lordships. Grateful.
Yeah.
Or to 218.
118.
18 minutes, I beg to appear for the respondent.
Lordship, Mr. Secretary, there is the on record in this matter, Your Lordship, for the appellate, for the petitioner, Your Lordship. Now, he has told me that the instructions that were supposed to come,
How can gmail.com can be an advocate on record?
and that has been a mistake, by mistake, Your Lordship.
Gmail.com.
By mistake, that has appeared in the list, Your Lordship.
Follow it a key. What is this?
Debrut,
Have you served a copy?
Yes, this is not the first time, Your Lordship.
was there.
Now, Your Lordship, perhaps,
Have you want to file reply? Because you are supposed to file reply.
no, Your Lordship, perhaps there is the compliance had been made, but there is no written instruction as on date, Your Lordship. So, if Your Lordship kindly keeps it in the next week, And
What with the instruction? The compliance has been made.
No,
then it's made.
I am not sure about it, Your Lordship,
Not sure, then why you're saying so?
because that's what my learned Mr. Chaudhary has told me that perhaps
Where is Mr. Chaudhary?
he has not come, Your Lordship.
Why?
His fever, he's going through a fever, Your Lordship.
Not today.
119.
This matter, my lord, I am for the contempt. Now, as per your lordship direction, my lord, I filed the affidavit in opposition.
Give me 1 week time
What?
for filing.
Let the affidavit in opposition. Is the individual or the collective affidavit in opposition?
Individual.
Let the affidavit in opposition filed by the alleged contempt be taken on record. Counsel for the appellant, the petitioner, please for extension of time to file a reply. Let the reply be filed within a week from date. This is the matter recorded. Next.
220.
Yes.
222. So nobody.
Kindly have my contempt application minute at page 18. But this is that matter where the plaintiff had sought for partition and alternatively enforcement of a family settlement. Yes.
Was the order and what is?
But your lordships had recorded.
To have been violated.
Yes, minute. No, your lordship had recorded a concession or a undertaking from both the parties rather that they will not alter the assets or liabilities. That was the concession recorded against which an interim order was not extended because initially we were enjoying an interim order. After hearing the matter at length, your lordships had recorded a concession from them that he will not alter the assets and liabilities.
Where is that order?
Please kindly have page 18 minute.
Is the order dated 13th of September?
Yes, minute.
Yes.
Yes, minute. Kindly comes to internal page 2 of the order, second paragraph.
What has happened?
This kindly comes to page
But
32.
according to me, that is the interim order. No,
Lord, we had
At the logger's head
I'm at Logos. They want to fight.
or on a dragger's draw?
Lord, he wants, his client wants to fight, Millard,
What,
basically. Millard.
logger's head or a dragger's draw? What?
Draggers drawn, Millard, probably from what we perceive, Millard.
That these, Milord, there are some brothers, Milord, who will continue fighting. These are two of them.
Beneficial for
The bar. For the bar. Our duty is to try and drill some sense into them, but some brothers, Milord, want to fight. Now, Milord, we treat this as an interim order, Milord. It's not assurance, is like an order of court. And I'll show your lordship that there has been no violation per se, what they say.
What have they sold?
What have they done?
Have they done anything, with the
They have taken additional loan against the same properties which were.
by putting as a mortgage?
Yes, Millard.
No, Milord, I'll show you.
Mortgage.
Yes, Millard. Millard, I have annexed the documents.
Was that property under a mortgage?
Millard, it was earlier under mortgage, let's say for an extent of 100 rupees. Now they have made it 500 rupees. So the liability has.
Let me show your lordship. No, that's not right. I've got all the papers to show your lordship. If your lordship
Millard,
feels.
Before going through what Mr. Chaudhary is handing over,
No, I agree what you're saying. I agree.
There is clear contempt.
No, it's not clear contempt. I'm saying it's not a contempt. You're alleging, Milord, kindly see the letters of sanction once, Milord. It to them other side ki copy them. What you hand up, you have to give. Milord, please, Milord, take the first page.
Bank of India. And this is the 28th March.
Yes, it's subsequent, Milord. It's subsequent. Milord, this is approved takeover. So now what has happened is, from Milord, Canara Bank, it's come to Milord,
Central Bank of India.
That's the switching over. of
Switching
the
over.
bad loan.
Yes.
Yes.
Now, cash credit, my lord, was 70 crores. And, my lord, if your lordship takes, my lord, the next page, term loans were, my lord, 20 crores, 21 point something.
Cash credit was
70,
95. No,
cash rate was 70.
at the bottom, present proposal.
Yes, my lord, please, let me read, my lord, the first box. Approve takeover the existing cash credit limit of rupees 70 crores with an
I am unable
my lord,
to-
first page, my lord, right at the top.
Okay.
Approve takeover the existing cash credit limit of rupees 70 crore.
25 crores.
I am
No,
unable
no.
to find out.
25 crores.
Oh, the first bullet point of the first block.
Yes.
আমারটা হয়তো
What have I
Fresh
given you?
sanction.
you have given me this 25 crores.
Oh, I've given you a wrong
No,
document.
it's completely,
one-
my lord,
Full document.
this is not the full document, this is the
This
correct
is the
document.
wrong document.
My lord, it is, the credit limit was
borrowed a
25
key.
crores and this was enhanced to 70 crores.
No, no, I am giving the 70 crores.
Oh,
What are you?
Sir, have I given
The earlier one,
No,
sir, have I
this is
given?
not.
28/3/2024.
This is also
Yes, my lord.
28.3 Central Bank of India. Now, this is the
now.
correct one.
এটা তাহলে আমি এটা চেঞ্জ
That
করে
may
দিচ্ছি
be a
even more
proposal
serious.
talk going on.
Miller, I have nothing to hide. I have given everything. Miller, may I show you please, bolte dao na, tarpor bolbe. Approve takeover the existing CC limit of rupees 70 crores. Lordship has seen that.
25 crores. And enhanced limit by 70 crores.
Yes.
Miller,
You have
this is
given
this is the relevant one. That's for another
My
company.
lord, kindly keeps that.
Keep it. I have no
Kindly keeps
problem.
it.
I've got nothing to hide.
This is how they are, my lord, hoodwinking
May I
not
show
just
you
us, but the court as
May I show your lordship?
initiates an inquiry into this.
Yes, yes, of course. Approve takeover the existing CC limit of rupees 70 crores with an enhancement of rupees 20 crores. That is total CC to the extent of 90 crore, enhancement of 28.57% in the existing limit with Union Bank of India. So, my lord, their complaint is what was earlier 70, how could you make that 90? Now, my lord, please turn over to the next page. Right at the top, accepted ICR such and such. There are two existing term loans, GECL 2.0 and GECL 2.0 extension to the extent of rupees 21.56 crores. Current outstanding is 18.15 crores, which is not proposed to take over, and the same to be closed from promoter-owned sources before releasing limit to the company. So, my lord, what has happened is these two term loans of, my lord, 21.56 crores are, my lord, not continued. Instead of these term loans, the CC limit is increased from 70 to 90. So 21.56 comes down and 20 goes up. So if at all I've done something, I've reduced the exposure against these properties by 1.56 crores. This is what has happened. Let them dispute it. I am totally clean. And in contempt jurisdiction, it is not only proper to show everything to your lordships. This is the situation.
Sees both, kindly sees both,
অন্যটা কি দিয়েছে আমি
the
বুঝতে
what they
পারছি না।
gave. এক second দাঁড়া, আমি বলছি। This is the next at page 32 as well. Suddenly, my lord,
That is what a
a
different
person-
company,
that's
Mr.
exactly what I'm
Chatterjee.
trying to show.
See that.
Mr. Chaudhary, I'm trying to show that to
You-
my lord.
Show that.
This is a company, my lord, which again, what happens here is the property involved in this is also in the hodgepodge. Here, direct, my lord, thing is that he's increased it from 25 crores to 70 crores.
By 70 crores.
By 70 crores. And then now he comes up and saying, I'm a Sadhu Purush and I've brought it down to 1.5 crores. No. My lord, both of them, my lord, what they've done is they have enhanced, my lord, their credit limit showing my property. Giving your lordship my lord, my lord, what would I say, my lord, a scenario as if that he's trying to, my lord, do something, my lord, without getting the properties involved. No. In every, my lord, Every transaction, the property is mortgaged. And he's told your lordship that he's not going to do anything with the property so that the settlement can happen. In the settlement, it is my way or highway. You agree to the family settlement, whatever happens, give it to me. I don't have a problem at all.
Why you say highway?
But that's what the language is. See, when we sat with Mr. Mitro, my lord, Mr. Chaudhary was also there. My lord, we said that whatever is there in the family settlement, all families were involved, came to that, give it according to that. You have your share, I have mine. There is no dispute on that. But he will not do, my lord, and
No,
behind the back, he's, my lord, at that
I
point
dropped
of-
out of the settlement, my
Chaudhary, I
lord.
did
Mr.
not-
Mitro was there. I could understand that these
I did
people will not settle.
trouble you. Did not trouble you.
You're
I'll
always
come to that.
troubling me.
You've troubled me for quite some time in many ways, in more ways than one. So allow me a trouble-free audience before his lordship. Now, my lord, the situation is that you give a scenario
Bitterness has come.
with him. How well?
Why?
How well?
My lord, I will tell your lordship, please don't rely, my lord, on these two people, because why will I give your lordship a wrong impression? These people don't want to settle.
We would
So
And all
many
this
settlements I have
while-
done.
All this while, when the matter was being heard, I am ready to settle.
No, this is my perception personally.
says that as a council, when the court has entrusted a certain task, that it is my pious duty to do so. Then he say, I attempted. And now.
He didn't
out
attempt
of
anything.
dismay-
Again, I'll tell you.
Out of dismay, he says, the litigants are more interested in litigating
Well,
than to.
My lord, I'll tell your
I'll tell
lordship
your
one
lordship,
more thing.
he was not even there, my lord.
Because I know it's
He
a,
wasn't even there, my lord, in the when the settlement talks were on. It was I with Mr. Mitro.
no, Mr. Anino Mitro was there.
Mr. Mitro, senior Mr. Mitro.
My lord,
And
I'll
Mr.
tell your
Mitro was
lordship,
on, my lord, on
2 weeks back, my client told me I want to settle the matter. I told him that you first give me your terms of settlement, sign it and give it to me. And if you deviate from that, I'll hand it over to the other side. He hasn't come back to me after that.
to such a
And
client,
his
my lord.
client is also equal, my lord.
Arey, why? I am
Both
saying my
brothers
client
are
is
equal.
ready. I am saying my client is ready. Whatever is there in the family settlement, adhere to it. There's nothing beyond that. You said that, my lord, family settlement was given.
Come at two.
Ah,
I have a bench at one,
at two.
regarding the
Milord,
determination of the honorable chief
Two,
justice.
Milord,
Two, my lord, honorable courts have fixed appeals, my lord, for hearing.
The appeal against rejection of, yes.
Why?
Because the Honorable the Chief Justice felt that this bench should.
Not appropriate. No, Mr. Advocate General, you ought
Even
not to have said that. You ought not to have said that.
No, that I have said after.
Oh.
Milord, Mr. Justice Bhattacharya is here. What I said was after his lordship, I mean the Honorable the Chief Justice was of the opinion that it should be heard by this bench. Then I said that yes, for this matter, Justice Bhattacharya had made some research. Not before that.
Say something different. Say that me who has formulated this point,
No, that is in the order.
and therefore assignment has come.
Therefore, your lordship will hear it. This bench will hear it. But kindly give a date, Milord. We understand, Milord. But the other matter, number but the other matter is that review where your lordships were pleased to direct us to serve of this bench.
Give it here also.
Very well.
We are sitting from Monday also. There is no difficulty.
Very well.
May I have lordship?
But give us a date so that we can prepare us. I mean, because in that review matter, I need some time to prepare myself.
No, review is with us. So there is no difficulty. We can sit.
But I was only requesting this. If your lordship may give a date today, why? For my benefit.
Come on Monday.
Monday, I come prepared.
Come prepared.
Very
Either
well.
in the morning or in the afternoon.
Very
That's the only.
Very well.
May I
Well-
have your kind indulgence to mention one appeal, my lord, for leave, my lord, without the certified copy, without the server copy, day before yesterday, my lord, the order was passed. It has been signed but has not been uploaded yet. Tomorrow, my lord, I have to hand over the site.
Will be uploaded today. You will get a sign.
I mean, I have annexed this counter server. This
Next week, go and file an application for certified copy immediately.
I have filed, my lord. I have annexed it. But server copy, my lord, is not available. It has been signed today, my lord, but it has not.
Go and check whether it is available now.
My lord, is subject to, my lord, kindly grant me, if lordship leave, I will undertake that it will be annexed along with this.
Once you get that server copy, file it. Take leave and file it. Otherwise, the appeal cannot be heard
I understand,
without
my
the
lord.
order of the.
Only the day before yesterday, the order was passed, my lord. That is the difficulty.
There are two ways of doing
I
it.
have followed, my lord. I have followed the discussions.
Nowadays, the server copy is available. In earlier days, the advocates used to write that what are the orders after looking into the file, and then
My lord, only the difficulty. Only the difficulty is this, my lord. Tomorrow I have to hand over the site.
disposal matter or
It has been disposed. My
What is the grave urgency?
urgency is this, my lord. I was operating one cycle stand of the railways, my lord, and there is a clause of renewal. Now, tender has been floated, but same has not been finalized. If that is the case, my lord, I have a right of operation for a further period of 6 months upon payment of 10% hike over the license fee. But that has been turned down, my lord. Tomorrow is the last date of handing over. But they have not yet.
they have already finalized.
No, they have not finalized. They have not finalized.
The handing over means what?
My lord, they have not yet finalized.
No,
And under the clause, I can demonstrate
you
that I have a right of operation.
Huh?
I have a right of operation, my lord.
Whatever you.
Well, if that be so, my appeal will.
Annex the copy of the order and hand it over to our officer.
Grateful, my lord. Yeah, I will do. Grateful.
May I have your lordship kindly to file this without certified copy. I have annexed the server copy on the date of order on 14th
Have you
January.
applied for certified?
Yes, yes, my lord.
Have you annexed?
Not annexed, copy is
You have
there.
to annex.
No, I just know I will annex.
The order is passed.
14th January, my lord. And on same day I have applied. On same day I have applied. And my lord,
Now you have not obtained the certified copy.
no, my lord. So on the same date. Certified copy.
My lord.
And my lord, date of auction, my lord, on 29th January. My lord, can you please?
Please give annexing. We have granted you. We have granted a leave.
My lord.
File.
My lord, I am praying for leave to file this appeal, my lord. My lord, I have applied for certified copy, my lord. But my lord, I have not been obtained certified copy, my lord.
the server copy?
Yes, my lord.
What is the date of the order?
Date of the order, my lord, 11 December 2024, my lord.
Was the normal period of limitation is expired?
My lord, my lord, I have annexed copy. I have applied within limitation, my lord.
It may stop the limitation, but when you wanted, why you did not come on 14th of December?
My
Why
lord,
you did
my-
not come on
my-
15th? Why you did not come in the month of December? It was so urgent. Why you waited for such a long time?
My lord,
The normal period has expired.
my lord, I have applied for certified copy on
Why you
7
But I'm for the petitioner. When the when the respondent in the matrimonial appeal, which was preferred by the husband against dismissal of the suit for the dissolution of marriage on the ground of desertion, cruelty, and other things. But thereafter, the appeal was preferred by the husband. An application for alimony was taken out. Well, interim alimony was granted by your lordship's coordinate bench. Subsequently, it was been affirmed by your lordship. Well, that order has not been carried out. But if your lordship may kindly comes to page 39 once. 39 of my application for contempt. Well, from January, only January 2021 was paid. From February, your lordship directed, kindly come to the operative portion at page 40. Well, he appeared for the applicant, but for the wife. For the wife.
Oh, applicant responded. Husband is not.
No, there was a previous direction, my lord, to serve the copy, and it was made returnable, my lord, on kindly see the order dated 30th of August 2024.
No opposition filed.
Nothing. Not they have paid any amount. Well, this is the amount that I have calculated. If my lord may kindly takes into consideration. It is my lord. But this is the amount due and payable from the date of the order.
The instant contempt application is taken up. Alleging the volume of the order which is changed by 2023 passed by this way. Thereby,
this is
the applicant was directed to pay the area monthly maintenance of rupees 6,20,000 within 3 weeks from the date in the same manner as has been done earlier, and shall continue to pay the current monthly maintenance at the rate of rupees 20,000 per month on and from the month of September 2023. That is, the 6,20,000 not paid.
Nothing. And as on date, it is 9,60,000.
The said order was duly communicated. Where is the communication?
My lord, this is the affidavit service.
Duly communicated to the applicant.
It have affidavit service.
But despite having knowledge of the said order, not a single farthing is paid to the applicant. The contempt application was directly served upon the appellant. And after service, the matter was made returnable on 30th August 2024. So, on the same date, this court directed the contemptor to file affidavit in opposition to the contempt application, which according to the learned advocate for the applicant has not been filed. In absence of any counter affidavit having filed, we can safely proceed on the basis of the amendment made in the contempt application by applying the doctrine of non-traverse. There was a specific direction upon the area maintenance and also the current maintenance month by month, which has not been paid, and therefore there is an apparent violation of the order passed by this term. In view of the above, let the rule be issued upon the LS contemptor to stop. The rule shall be served by speed post with acknowledgement due. The applicant is directed to file the requisites
by next week, by Tuesday.
Within a week from date. Stop. Immediately upon deposit or upon filing of the requisites, or immediately upon filing the requisites and the cost for effecting service within the time indicated herein above. The office is directed to effect the service of rule upon the alleged contempt now. So the rule is made returnable after 3 weeks.
My lord. Well, affidavit of service may be kept to the record.
That is already on the last office and it has been set for the court.
My lord, actually, he's engaged one lady.
আরে একটু কথা বলছি আপনারা যথেষ্ট একটু বলতে
He's engaged one lady.
Please tell her that it's not the way. When she has engaged,
My lord,
she should come.
I am really in a fix, my lord. I to instructed her not to make any submission before the honorable court.
What she want to say must be told to you and then you communicate what she wanted to say.
আরে এটা তো ম্যাট্রিমোনিয়াল শুটের ব্যাপার, অ্যালিমনির ব্যাপার নয় এটা। Grateful to
Well, I appear for the alleged contempt in this matter, my lord.
I am appearing for the petitioner led by Advocate Anjan Bhattacharya, Lord.
Perhaps, my lord, this contempt is not maintainable, my lord. Your lordship had directed the school authorities to take a conscious decision, my lord. If your lordship kindly sees your lordship's order dated 9 July 2024. Well, at page 22 of the contempt petition, my lord. Para 2.
Directed the appellant to submit the downloaded copy of the application from the portal and shall also annex the documents which form part of the attachment to the said application at the time of uploading the same when the portal was active to the school authority.
I am for the school teacher in charge, my
So
lord.
take conscious decision on the application and being satisfied shall issue an objection certificate.
Yes, my lord. My lord, we were never a party to the writ or the appeal, my lord. The DI, my lord, had communicated a letter, my lord, to us.
Have you aware of the C-word principle?
Yes, my lord. My lord, may I, my lord? May I, my lord?
Non-party to the proceeding can also be
Absolutely,
held
my
in
lord.
a contempt.
May I apprise your lordship of
He is
what
aware of the order being passed.
I beg.
So
My lord.
have you done it?
Yes, my lord. We have taken a decision, my lord. Yes, my lord.
You are straight away.
Pursuant to the, my lord, the first page is, my lord, the letter by which the order was communicated to us by the DI, my lord. Second page is the decision, my lord, wherein, my lord, we have informed the DI. My lord, your lordship will see
Why you have not
para 2, my lord. In support of FAQ addition serial number 2, we beg to apprise you of the fact that the number of teachers, including the head of the institution, is 19, only for both secondary and HS, and the present roll strength is 2205. Thereafter, my lord, as there are merely 4 Bengali teachers, including AHM cum TIC, it is quite not possible for 3 teachers to take classes for a roll strength of 2205 students, my lord. Besides, there is only 1 clerk appointed in the HS school, so HMTIC is compelled to do clerical works beside his own duties for better conduct of the school. This is the reason, my lord.
go beyond the mandate of the rule?
No, perhaps not, my lord.
What you have done is against the mandate of the rule. One teacher, single teacher cannot be a ground for rejection.
No, my lord.
If the other grounds are found to be genuine. Have you seen the 3rd January 2022 notification of the governor?
Perhaps not, my lord. Yeah.
Show him. Show him. Hey. Below block.
That is so.
If you cannot,
That
then,
is so.
then are you not bound by those statutory
Absolutely.
rules then?
Absolutely. I am, my lord.
That
I
shows
only
that you
wanted
have
to
not
apprise
acted.
your lordship what has happened, my lord.
What happened? There is nothing.
I leave it to your lordship. I leave it to your lordship.
Then we are holding you as a guilty of contempt for that.
Lord. Well, may I
What
come
you
back?
can do?
In that case, my lord, may I come back, my lord? May I come back?
And this is for the second.
Yes.
Previously, the rule was that single teacher was there. Then this notification came and it says no, can't be a ground for rejection.
That is true. That is true, my lord.
So,
May I? If your lordship kindly takes it up after fortnight, my lord, may I come back, my lord? I have to apprise my lord.
Have no authority to say.
Yes,
You can only say.
that is true, my lord. Absolutely.
And there are another judgment of the coordinate bench which says that you don't have an authority to say no objection. Only restriction is that if there are more than one application, and if the 10%
Criteria.
the criteria is to be adhered to only,
Yes.
and that too on the ground of seniority. This can't be. Is your problem how it's to be done, and the TI will take care of that.
My lord, may I apprise this to my lord and come back, my lord?
And he's a teaching staff,
Absolutely.
So-
He's a teaching staff.
clerical job. We want who is the
My lord, the teacher in charge is the contender, my lord.
we want him to be personally present before us.
That will do, my lord. That will do. Your lordship kindly takes it up after a fortnight, my lord.
On the prayer of the learned advocate appearing for the contender, let this matter be listed after fortnight.
I would like to, your lordship.
Lord, I beg to appear under the alleged contenders.
Use always the word beg.
But only short.
I just requested you not to use that word beg.
Lordship, sorry.
That was the colonial expression.
Lordship.
You have a right to represent your client.
Lordship,
I am praying for short passover, my lord.
As well as the
Lordship, kindly
I pray-
excuse me.
you are beg to appear.
Kindly excuse me, Lord.
I am praying for.
This business is not really from the responsible faculty of the judicial side.
Lordship. I understood. Lord, may I file my affidavit of compliance, Lord?
Short passover, my lord. Mr. Bisharu is coming. My lord, short passover.
No, not, then we are not.
Compliance.
Well, this is the compliance report. You have
What was the direction?
direction to consider within 4 weeks.
And rejected, obviously.
No, Lord. Lord,
Have
we have
allowed.
taken
Yes.
certain steps. If your lordship kindly goes through, Lord, these, Lord, certain steps, necessary certain steps have been taken, my lord. That has been, details have been narrated from paragraph 4 onwards. Lord, may I place, my lord, at page 6? My lord, first of all, my lord, my client tenders his unqualified apology for the delay, my lord, for your compliance of your lordship's order. My lord, paragraph 6, my lord, starts from paragraph I. My lord, certain necessary steps are being taken, my lord.
এটা compliance হবে?
দিতে নিস নি, my lord. দিতে নিস নি, তোকে দিতে গেছিল। এখন না।
Sir, I tell you, this is a farcical approach.
My lord, what?
If you depend upon the consent of any of the teacher, then I think this third January notification should be scrapped, should be scored.
Lordship.
You are the authority who can mandate any of the teacher to go and do these jobs in a
Lordship.
nearby school.
Lordship.
You have an authority to dictate them.
Lordship, my lord.
You will just sit that give me no objection. Yes, you want to do it.
So, my lord, I read your lordship's mind, I do it, my lord.
What?
Give me, my lord, for
Objection
fortnight.
has not been received. Then this the provision has to be deleted.
My lord,
Do it. That's the
Lordship.
notification. Withdraw it. Withdraw it.
My lord, since, my lord, we could not get any names, my lord.
Why you will not? You are a district inspector of school. You have an authority to command. Don't you have?
Lordship, my lord.
So, if you cannot command, then you are not a good administrator. It's better to quit. In nearby school, you can say that yes, in the first half you can take a class, second half you come and take these classes. What is the difficult?
My lord, we have taken all the steps, my lord, since I have read.
You have written to the headmaster, please tell me any teacher. is
All the
interested."
schools, all the school under Agra subdivision, all the school, headmaster of Agra school.
You know who are the teachers.
Milord, yes, Milord. Yes, Milord, I have read your lordship's mind, I have conveyed.
Your own notification.
Milord, I have read your lordship's mind.
Your duty to see. It does not say that you will ask for an objection. If somebody agrees, then and then it can be done. Amend it. Amend it. Why you have included this provision? It's a clear mandate on you. You will make an arrangement. How you will make an arrangement is your job.
Let me, Milord, come back.
Next
Next.
Friday.
Milord, 2 weeks, Milord, 2 weeks.
No 2 weeks.
22. Yes, 31 is a replica of 32.
Take
That
back.
has been-
You are not taking it.
My
Lordship, Milord.
The affidavit of compliance filed today is taken on record.
Oh, sorry.
On the prayer of the elders contemptor, let this matter be listed
31st.
for a Friday date.
March of Christ.
Careful. Extremely grateful. Ram, sir.
May I take it,
Call
Lord?
the next.
Grateful.
Call the next. Now. Of application source this way.
Yes, Lord, I beg to appear. I am appearing on behalf of the Lord, private respondent, Lord, this concerned school, madrasa.
Lordship, I am for the appellant. I am on behalf of Miss Senior Advocate Vikas Ranjan Bhattacharya. I am praying for not this week, Your Lordship.
Not this week, Ajke Tashuk, not today.
Not today.
Okay, not.
I'm grateful.
Next.
Milord, in this matter, Milord, I am led by Mr. Aurobindo Chatterjee, learned senior advocate. He is Aurobindo Chatterjee, learned senior advocate. He is out of station, my lord. Let it be taken up Monday. And my lord, in this matter, my lord, another appeal has been preferred by me that
There's a cross appeal being preferred by them.
Yes. Yes.
Can appear.
Lordship.
So,
Keep your best.
After that.
both configured together.
Yes.
My lord, in 68, my lord, Mr. Shumon Banerjee is appearing in this matter for the appellant, my lord. I am praying for a not today, my lord. My lord, he's on legs on other court, my lord. My lord, kindly, my lord, kindly, my lord, grants a not today, my lord.
I'm giving you a provision of the act.
My lord,
Read it.
my lord, Mr. Kolal Basu is appearing in this matter as my lord, he
According
will,
to him,
my lord, he will address your lordship, my lord. May kindly, my lord.
এদিকে যে tag আছে plus C পড়াও read it plus C
Back to the pleader. And my kindly.
So this is the law, we are bound by the law, so do you.
My lord, I bound by
It
my
says
lord.
that it's not a ground for adjournment. What can be done? So we can't grant you an adjournment.
My lord, kindly, my lord.
What kindly? Can we go beyond the statute? Tell us. That
My lord, they
regulates
kindly
the
grants a short
interpreting.
passover, my lord. My lord, may kindly grants in the short passover, my lord.
Passover.
My lord.
Give back the book.
Yes.
But I appear for the
My lord, in item number 69, my lord, Mr. Ujjwal Rai is appearing on behalf of the writ petitioner, my lord, respondent. My lord, his wife, my lord, this morning has fallen ill, my lord, all of a sudden, my lord. My lord, kindly grants 1 day accommodation, my lord. I'm so grateful.
69. March of Christ.
কি হলো দাও ডিফেক্টিভ আছে জাস্ট ফাইলটা এমনিতেই দাও জাস্ট ডিফেক্টটা দেওয়ার জন্য মেমোটা দাও শুধু মেমোটা দাও বাস সেকশন 5 আছে Section 5 আছে? আছে? Next, 71, find out defective, কেন? Granted by the honor court. আচ্ছা।
কপি ফাইল গেছে কিছু দেখা যায়
আমরা বলো এখানে দেখবে না তো মোকালেতামা আছে কিনা সেম অ্যাডভোকেট যে অ্যাপিয়ার করেছে স্টেট একটু বন্ধ দেবপ্রিয় দেবপ্রিয় সাবন্ত করেছে একটা মোকালেতামা দেখবে না উইদাউট মোকালেতামা উইদাউট মোকালেতামা না না ডিপার্টমেন্টে কি লিভ নিয়েছে দেওয়ার সময় দেখবে না যে এটা মোকালেতামা আছে না সেম অ্যাডভোকেট হলে অসুবিধা নেই Yes, who is in 71? What is this defect? Will you not file Wakalatnama?
Wakalatnama. I'm extremely sorry. I'll have to
Took the leave. Where is the certified copy?
certified copy. Near Sonara. It is with me, madam. This is the certified copy is with me.
Yeah. Where is who is the advocate on record? Where is he? Devapriya, I do not know whether she or he.
He, madam.
Where is he?
He's right now not here. He's in court.
And without filing the Wakalatnama. He was not a advocate on record in the trial court. Subroto Mondal appeared. How can he without the Wakalatnama?
I'm extremely sorry. I did not know. This should not have been done. I'll just. Myra will kindly keep take it up on Monday. In the meantime, I'll ascertain what has happened.
What is the date of your?
On merit, the impugned order has been dismissed, but not on merits, merit.
Dismiss. We are going to dismiss the appeal.
But I'll.
Don't take the court for a ride.
No, I cannot. Man, I did not.
What is the period of limitation for filing the appeal before this court? Inter-court appeal?
30 days.
30 days. Then, if you apply a certified copy within 30 days, then the limitation will stop. If you apply beyond 30 days, then
beyond it cannot stop.
Then, what you have done? This is the regular practice. We will stop granting any leave to anybody. You have annexed the copy of the application for certified copy, which appeared to have been applied on 22nd of July 2024 against an order of 16 July. Look at the certified copy. You obtained on the basis of an application filed on 27th of September.
There must have been some. Application is certified copy.
Now, take it away. Last page.
I'm extremely sorry. I am not the advocate on record.
Look at it. What is the date of application?
Some other copy.
And what is this you have annexed? 22nd July. That means you did not pursue this application for certified copy. Then why not the limitation will come?
May I come back on Monday?
Come back. According to the appellate side rules, It has to be returned to the advocate and record. We are directing this to be dismissed.
I will kindly take it up on Monday, my lord.
No.
So, since my advocate on record is not there,
Wakalatnama is not filed. So casual.
this should not have been done at all. I did not know. I did not know this. This should have never happened, man.
This is the reason we insisted. Mr. Ali in the morning asked that why you are insisting for this application to be annexed. This is the reason we want.
I will kindly keep it on Monday. Since the advocate on record is not there, I could not take instructions.
Not today.
Lord, Mr. 74.
72.
My lord, 72, my lord. Mr. Ujjwal Rai is appearing on behalf of the appellant, my lord.
Not today.
I'm
73.
No, my lord, I am praying only not today. Only. Brief is not with me.
Only word is a very ambiguous word.
Monday I will finish it.
This only word is a very, very ambiguous word.
My lord.
Have you seen Mr. Mrityunjay Palit?
Which Ali?
Mr. Mrityunjay Palit.
Mrityunjay Palit.
You have seen him?
Palit.
Not today.
What is my opinion?
Lord, my pay scale has been reduced after my retirement.
The authorities are against you.
No, Lord, I am, Lord,
I do not know. Why? Such a renowned personality, and you are against him.
Lord, kindly.
Look at the name.
My lord.
Consider the application also.
Lord, I am covered by my Lord's judgment, my Lord.
That was a wrong judgment.
আপনাকে দেখছি
Check.
Contempt.
Hmm.
13.
You're enjoying the postgraduate scale of pay.
Yes.
Till the date of superannuation.
Yes. And I enjoyed it before the Control Expenditure Act came into force. Even before the 97 School Service Commission Act into force.
Why you did not invite the attention of the court to a judgment? Special bench judgment?
Lord, possibly, my Lord, this judgment, the impugned judgment at page 87.
No, we are looking at the memorandum.
Yes.
I am talking about the special bench judgment rendered by this court.
My Lord.
Considering all various.
Yes, yes.
Why you did not cite it?
Lord, I take up the responsibility, although I was not there, my Lord, I take up the responsibility, my Lord, but kindly sees, my Lord, the court knows the law, my Lord. I go with that presumption, the court knows the law.
No.
And
No, unless you argue why the court will.
No, I was
make out a
arguing,
Case for you.
No,
There are judgment that the court is not supposed to make out a new case for a party.
no, my case was, my case is simple, that on the date of my retirement, I was enjoying this pay scale. Now they have reduced my pay scale on this ground that I'm.
Can you do it after superannuation? Can you do it? I'm asking.
Lord.
Traffic mercy, then there are many judgments that you can't.
Recent, Jagdish Prasad, 2024.
Lord, kindly,
Justice D.Y. Chandrachud,
Lord, then.
as his lordship.
No, that is Jagdev Singh.
Jagdev Singh.
Now, Jagdish Prasad, is very recent, This is by Justice Mehta and Justice Mahadevan.
Mahadevan and Justice
Mehta.
Mehta.
What do you say?
Lord, this was my Lord.
Justice Vikram Nath's judgment is also there.
Yes, yes. And then, I am before a court, relying on all these judgments, my lords have passed a judgment.
Remind back to the learned single judge, honorable single judge, my Lord. For
Straight away, these are the law staring at your face. Can you do it? Till the date of superannuation, you have extended the postgraduate.
till the superannuation. Thereafter, it was not given.
After that, you wanted to fix the pay, the pension.
And this is the order, my Lord.
Postgraduate. Can you do that? Why you did not take steps? They do not want a recovery.
Lord, they have recovered only a part of it. Then, since the list was pending, Lord, they have not done anything more. But I will not have, my Lord, kindly, I have prepared, a supplementary affidavit, if my Lord kindly permits me. The pension payment order was pleaded in the writ petition, was not annexed. Lord, I have prepared the supplementary affidavit only to invite my Lord's attention to the amount which
impugned
has
order
been
in the
deducted.
writ petition at page
I have
51, my
seen
Lord.
The impugned order,
Lordship.
absolutely contrary to the special bench judgment,
Lordship, then
as well as the other judgments of the Supreme Court on different score.
then, my Lord, let it be.
You want a perpetual, I would say, the resurrection of the litigation, or you want
Not
an
that
end
if,
to-
if, my Lord, it was perhaps not produced before the DI concern. Therefore, and my Lord,
Okay, till the date of
yes, yes.
after superannuation, release করছে যখন retirement benefits কেটে নিচ্ছে, pensionটা past graduate করে দিল. This is not good. This is not good. Right. So prior to coming in force of Expenditure Act, Control and Expenditure Act, 2005.
My Lord. Utpal Karan, my Lord, has decided these issues, and very painstakingly, my lords have laid down the law insofar as, my Lord, the entitlement. That is one part. But the second part is, after I've retired in 2015, in 2019, they say that I was not entitled to the pay scale I've been enjoying for the past 25 years, and that stands reduced to this amount, and my pension is reduced.
You were granted a pension at the initial.
No, I was granted the scale throughout. I enjoyed it till my date of retirement. After retirement, my Lord, when I came before this honorable court in the previous round of litigation, my pensionary benefits were directed to be released. They reduced the pay scale and granted me. That was the subject matter of challenge before in the second round of litigation.
How can you do that?
With the
Can you do that? Pension should be on the basis of a last pay drawn.
it was
Is it? Is it not on the basis?
no, your Lordship is then.
Last pay drawn was on the basis of a postgraduate scale of pay. Then
Therefore, he has challenged this or the impugned order.
so insensitive.
Then your Lordship.
They are not very sensitive. That's why they have approached. The government officials are sensitive and alive of the law. I think the 80% of the litigation will be reduced in the court.
Lordship. What
Definitely,
is the order?
Mr. Bhattacharya, Mr.
It is the,
Everybody. No. Not at all.
my lord.
Not at all.
What can be done?
Thank you. Give our judgment.
So this is 2024 SCC online.
Our judgment. The latest judgment we just gave.
Not the latest is this one.
Yeah.
Yeah, so citation take to আমার একটা হাতে দাও না নালে citation দিয়ে দাও
Mr. Chaturvedi, the problem is that every time when you take out, we have to say the citation is SCC online.
My lord.
Why don't you give a copy of the journal which is recognized? Either SCC must have been reported in SCC, must have been reported.
It takes some time, Lord, before Lord we get it on in SCC or AIR.
This was delivered when? Sometime.
Lord, this is Lord
August. By
August.
this time it might have been.
Yes, but I mean, this matter is running for some time, Lord. I took out the copies contemporaneously.
This judgment of the Supreme Court, because if you want to quote it, how you will quote the paragraph?
These paragraphs are there, Lord, in this.
I know that is a SCC online, then you will have to.
Lord, yes. Well, my lord is not Lord recognizing SCC online.
No. Question is not recognition. The question is.
Yes.
Pushing.
Yes, my lord, I have followed.
Should be uniform. Give the another judgment.
Lord, Rafiq Masi. It's Lord 2015, volume 4 SCC.
Give.
দুটো কপি দাও
Give one copy.
ওটা
Give
AIR
one copy.
একটা AIR নিয়েছো একটা
একটা copy.
Copy of the দাও।
Yes. Here, it's only copy দাও।
এই পাটটা পাঠিয়ে দেবেন।
Our judgment you have not brought.
My lord's judgment, my lord, I have a soft copy of it. I have asked my learned junior, possibly he has missed.
Submitted in course of this day. What is this? Special bench?
This is a special bench, my lord.
Mark the paragraph and give one copy.
My lord.
Yes. Call the next matter. Do it.
My lord, I shall.
আমার কাছে কটা পেপার?
কোথায় গেল?
Lord, I appear for the appellant. But certain very embarrassing things have happened. I must inform the court. Lord, 17th September, the order was passed. 19th September, the certified copy was applied for. 4th October, before this honorable court, Lord, leave was obtained without certified copy. The certified copy was yet to be delivered. Lord, 11th of November, on the application for certified copy, the requisites were notified. The requisites were valid for 7 days. The requisites, my lord, the clerk missed it. My lord, I take the responsibility for that. A fresh application was made on 9 January after coming to know. My lord, requisites were notified on 14 January, 14 January 14 January delivered, and 20th. Yes, my lord.
It appears that on hearing the counsel for the appellant,
I'm for the
it
response.
appears that the instant appeal would be to have been filed beyond the period of limitation provided therefore. Leave is granted to the appellant to file an application seeking continuation of delay within a week from date. Let the matter be listed accordingly.
The 76, I appear on behalf of the appellant.
I am for the state ballot.
My lord, defect is the, my lord, I find, subject to correction of my lords, my lord.
Section 5.
Yes.
Section 5 has been. There is a delay of 55 days.
There is a delay of 55 days.
This is scan number 2 of 20.
Name of the respondent numbers 5 and 7.
Yes.
In the memo of appeal do not find place.
Yes.
In the cost title of the trial court.
Yes.
How can you make a party without being pleaded there in the
My
trial?
lord, kindly, I tell you, lordships, my lord, kindly grant me, kind leave, my lord, to make an application.
What
Oth-
make an application?
Why I say, kindly see.
Name of the respondent number 4 also does not find place. No, which find place in the cost title is not there in the memo of appeal.
Yes.
Why?
My lord, it's a change brief, I cannot say, but I find only.
To inherit the asset, you must inherit the liability.
Of course, I only submit to my lords.
Why the district inspector of a school
Primary education.
is not made a party secondary education?
Say.
Why you have not made him a party here? Primary education. Whereas you made a secondary education.
I have only, my lord, I can submit to my lords. If my lords, my lord, considers the family is in a total distress condition, my lord. Nothing, the particular person, the appellant who is filing, he is selling vegetable.
No.
Now, why I say, because your lordships may kindly consider that, my lord, he was getting.
Nowadays, the online selling of vegetable is very lucrative, very profitable business.
I do not know that. I do not know that.
Vegetable is a very profitable business.
Miller, I do not know that, but only thing I can show from the records that, Miller, so far the particular person is concerned, at page 46, he was the mother, not the mother was entitled to a particular pension. Now, Miller, the pension has come to 13,500.
Well, in the
And two particular sons, they cannot, my lord, sustain, and I have nothing to say about.
Is there any provision relating to extension of time to make an application?
Extension of time?
Make an application. It appears that there must be a scheme or a rule. The rules must provide within what time the application.
Within, I am grateful to 2 years.
Is there any provision for extension?
No, I did not
No,
find that. Idea. That's the reason I'm telling just the dates for my lord's kind consideration. Father died on
14 September 2019. Application on 20th July to 2021 when you were minor.
Yes, and kindly see in the interregnum period, one thing happened. That thing is that, my lord, the wife, my lord, it seems, my lord, that there was an application.
Then wife is not coming before the court.
Not coming to the court.
So what?
Not coming to the
You
court.
have come before the court.
Now, my lord, I attained majority on 31/12/2021. I attained majority on 31/12/2021. This I can only say.
So
I say, my lord,
2 years after the.
now, my lord, only one thing I can say, my lord. What I say, my lord, kindly consider, and thereafter, whatever my lord pleases, your lordship may do. Now, my lord, it is an admitted position. Whether, my lord, I have a right or because there is no vested right insofar as
There is
competition.
a judgment of a Devobroto Tiwari.
Devobroto Tiwari, yes. Yes, as the judgment.
Just only
Arekta
one
din.
thing, your lordship may kindly.
Law has started
din.
in general.
Lord,
Live law has started.
my lord, I have never, because I purchase all journals excepting the internet. I am not acquainted. I cannot operate. I have SCC online, but I cannot operate. Therefore, accepting that, I purchase everything. these live law, these these things, my lord, I am not aware. Therefore, I cannot tell your lordships. But I find in my mobile, I found that live law every day, it is coming up and is giving something, but I cannot, I do not operate. Now, only thing your lordships may kindly consider that in this case, in a similar situation, a particular Millard order was passed. That order, Millard, I should draw. Yeah, I'm sorry, Millard, I'm sorry.
লিখে নাও না, সাইটেশনটা লিখে নাও, দেখে নাও। এই যে দি স্টেট অফ ওয়েস্ট বেঙ্গল ভার্সেস দেবব্রত তিওয়ারি, অ্যাপিল নাম্বারটা লিখে নাও, তাহলে তুমি দেখে নিতে পারবে।
Sir, what can be done? There are two things which says, one is that a compassionate appointment cannot be granted without any scheme being there. I think that goes against the Bina Pani.
Yes, yes, yes. Yes.
Bina Pani, what is that?
Millard,
Bina Pani? Bina Pani? Murmu.
Something that.
More big. No,
No, ওইটা না, বিনা পানি মুরমু। Yes, sir.
Yeah. And second, it says that if the application is taken after a gap of several years, then in that event it can't be.
Millard, I tell you, lordships, Millard.
These are the two grounds.
Millard, I tell you, lordships. Your lordships may kindly
Are you
consider.
aware of this judgment?
Millard?
Are you aware of this judgment?
No,
Have you
I
read?
should go through this and then,
Go through it.
that's the reason I have taken that's the thing, Millard, I have taken.
Copy.
Yes, yes.
একটা copy দিবি আমাকে?
হ্যাঁ, নাও, আমাকে এটা জেরক্স করে দিও, আমার একটাই আছে।
আমি জেরক্স করে এখনই দিয়ে দিচ্ছি।
ঠিক আছে, ঠিক আছে।
Take my copy, give it to him.
No, I will do it. I will do it.
After taking a photocopy.
হ্যাঁ, ফটোকপি করে তুমি দিয়ে দেবে, সেটাই।
I will get a photocopy, I will hand over him this judgment in course of the day. Raju, এটা এখন
আমি 1 নম্বরে বসি।
আরে বলতে হবে না তোকে, তুই 1 নম্বরে বসিস।
Not today only, come on Monday.
No, only one line order will let you logically pass.
The single bench dismissed the writ petition relying on a judgment of the apex court rendered in case of the state of West Bengal versus Devabruta Tiwari and others. Within bracket civil appeal number 8842-8855 of 2022. Wherein it is held that in absence that the appointment on compassionate ground cannot be granted in absence of any scheme framed by the employer, nor an application taken out several years after the death of the employee should be entertained. The counsel the senior counsel for the appellant submit that he may be permitted to go through this judgment so that a meaningful assistance can be rendered at the time of hearing. Stop. In view of the above, let this matter be adjourned for a day and to be listed on Monday, that date clear. Monday,
Date for Monday.
27.
To be listed on 27.
আমি এটা তোকে দিয়ে দিচ্ছি, এখনই দিয়ে দিচ্ছি।
Get full.
Call the name.
Your Lordship, I am for Northland. 77, my lord, I am for the respondents, my lord, 226, my lord. Respondent number 226.
For the appellant.
Respondent number 1.
I'm for the appellant.
This application, section 5. Have you filed section 5?
No, your Lordship.
5.
Lordship, we got the first order, that is first 1/3/2024. Thereafter, we filed a recall in the learned single bench.
Challenge the order of recall, don't challenge the parent order.
Lordship,
if you want to challenge a parent order, then you'll have to suffer a limitation. Under section 12 of the Limitation Act, when the limitation starts, from the date when the order is passed,
It passed in on 1st of March
there
2000.
is a 213 days delay.
But thereafter, we filed a recall on that, and we got the order on 20th of September 2024.
It was recalled.
No,
Does it amount to a merger of the order, parent order, into an order of dismissal? So as I'm talking about the limitation purpose.
right. So, Lordship, kindly allow us to make the hearing of the limitation then.
You'll have to first take out an application, then the hearing of the limitation.
Okay.
You have not filed the application?
Yes, Your Lordship. Kindly give us time to file an application for that.
It appears from the report of the additional staff reporter that the instant appeal is filed beyond the statutory period of limitation provided for filing the instant appeal. It is noted that there is a delay of 230 days. Stop. There is no application for condonation of delay accompanying the memorandum of appeal. Let the matter go out of this to enable the appellant to take an appropriate step. Liberty to mention.
Right. Grateful, Your Lordship.
Yes.
I'm appearing for respondent number 5, Lordship. Your Lordship, I'm appearing for the appellate.
What are these applications?
Your Lordship, can number 2 is the section 5 application, Your Lordship.
And number 2. So you have to pass first hurdle.
Your Lordship.
How much days delay?
Your Lordship, there is 184 days delay. The order was passed on 21st May 2024. Page 8 is the order. Para 7, page 4, we have explained the delay, Your Lordship. The conducting advocate was unavailable due to his personal reasons till August 2024, Your Lordship.
Just one minute. Which page?
Page 4, para 7, Your Lordship, we have explained it.
Just one.
দাদা এটা সুসুন্দরটা
Yes, what do you say? Just explain. Just explain the delay.
Yes, my lord, regarding condonation. My lord, do not record my submission. I have no objection. Do not record. My lord, person, judicial lord. My lord, sorry, my lord.
An application for condonation of delay in filing this appeal. beyond the period of repetition provided there. It is categorically a word in paragraph 7 of the instant application that immediately after the order was passed, the server copy of the order after being made available was handed over to the appellants so as to take a decision whether an appeal has to be preferred or not. The circumstances further reveal that part of the clerk of the advocated record and also who is the advocated record here? You. Who
Your
was the advocated record there?
Your Lordship, Ghanshyam Pandey was dealing with the matter in the for drafting the appeal.
Birth certificate is of who?
Ghanshyam Pandey's child.
Where is the Ghanshyam Pandey? Where is he?
Your Lordship,
Who are you?
Anamika Pandey, Your Lordship.
You are not a Ghanshyam Pandey.
Your Lordship, he's appearing. I'll ask him to appear virtually, Your Lordship.
Where is the Ghanshyam Pandey?
Your Lordship, he's appearing virtually, Your Lordship.
He is appearing, not he.
Your Lordship, he's just appearing, Your Lordship. Ghanshyam Pandey is appearing.
Is there?
Your Lordship,
He's there in the matter.
And also, what does the child now correct that? Prevented the appellant to file the appeal within the period of repetition. The relevant documents in support of the petition are annexed to the instant application. Even though the counsel for the state opposes the application, but we find that stop. We therefore condone the delay in filing the instant appeal. The application can two is hereby disposed of. Let can one be listed in the next week.
Your Lordship, leave may be granted to file the supplementary affidavit. I have annexed the writ petition and the in the stay application.
may be served, Lordship.
Your Lordship,
Will
I'll
be
send.
give
Your Lordship, I'll send. और कॉपी है और कॉपी है हम लोग का
the counsel for the applicant seeks leave to file supplementary affidavit annexing the relevant people which forms part of the record before the single page. Such leave is granted. The copy of the supplementary affidavit is served upon the appearing respondent in court today. List the matter in the next list stay application in the next week. Can one?
Lordship, a substantial part of the single bench's order has been paid, Lordship. The certificate
without prejudice to our rights because contempt proceedings were initiated. We have paid the
Lordship.
What?
The order they have challenged.
It is paid means?
Your Lordship, this matter is pertaining to gratuity amount. The subject matter of the matter is that in appeal, what is the amount a pre-deposit has to be made. So our contention is that only the admitted amount has to be deposited. The Honorable Single Judge has held that no, the certificate amount has to be deposited. So a contempt proceedings was initiated pending this appeal. We have deposited the same without prejudice to our rights.
Monday or Tuesday?
Your Lordship.
Obliged.
Sincerely obliged.
Would I beg to appear on behalf of the petitioner appellant before your Lordship?
For the
I'm for the respondent number 7.
I'm for the school.
I'm for the private responding.
568.
Affidavit of science. Lord, may I place the Lord impugned judgment under appeal?
No, you did not have to. I am a fast reader. Let me first.
My
take your
lordship. No, 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 no.
Judgment no bathroom. Judgment. Bathroom.
Yes, yes, yes.
How this is done, it is not on the basis of the, what do you want? It should be done on a majority basis or a cumulative, the averaging.
No, your lordship, what I was submitting.
What do you want to say? I did not get a very clarity, a clear picture from this. What you really want?
My
There
lord.
are 5 members.
My lord.
5 members have conducted the interview. They have allotted a separate marks. So what do you want? That how that marks have to be taken into account?
By 2 members, one elected member would have been selected.
I am asking you,
My lord.
these 5 members are there. What do you really want to do? Every member has allotted a separate marks in the interview. Correct? What do you want to say about this? What should be the method to be adopted? It's not clear from the judgment and from your argument also.
My
What do you
submission,
want?
my
And
lord.
what they have done? What they have done?
Your lordship has seen, the 5 members would be there. We will select the candidates who participated in the said selection process for the post of assistant headmaster.
What?
For the post of assistant headmaster of a
I
convent
have
school.
seen, madam, I have
So
already read. The
5
fact is known to
yes,
me.
yes.
Fact is known to me. You are trying to say that the teachers' representatives that should not be elected but selected. You have interpreted the word nirbachon. You have not said. These are the things I am aware. But one thing you wanted to highlight, that how that marks is to be computed and why the new panel is to be prepared, on what basis? New panel? I just wanted to know, because that is your one of the prayer, main prayer, to recast the panel. On what basis? You have used majority. I just wanted to know, what does it mean? Majority means what?
The petition, it was the prayer of the petitioner that 3 designated persons who are the members of the selection committee, they have awarded marks. But about 5 to some extent, about 5 marks. That is the headmaster,
What you
expert.
want, madam, just tell me. You wanted that the 3 members who are in majority have awarded marks, so their marks should be taken into consideration. That is what you want to say.
No,
and the
no, I am not.
marks allotted by 2 should be
Two
discarded.
of the selection members of the selection committee. One is panchayat nominee member.
Another is a teacher's representative.
My lord,
I am aware.
your lordship,
I am
get with
aware.
your lordship.
Not
What
that I have not read.
my submission was that the person who is judging my caliber or my performance in the interview.
These 5 persons are judging your caliber, your expertise, your knowledge, your competence. Now they have awarded marks.
What is the his earmarks? The panchayat nominee, what qualification the possess? This was my one of the prayer.
Why the rule? Why
For
the
the
rule?
reason, for
You
the
have
reason,
not challenged the rule to be ultra virus, that in an academics, what the panchayat member or a nominee will do, he does not have
but
knowledge.
according
He's
to
not a qualified
Honorable
person.
Supreme Court held that the person who is judging my caliber, he must.
Madam, when the selection committee comprised of 5 members,
That's true.
which includes the panchayat nominee, can you say that the panchayat nominee is incompetent to judge your
I
caliber?
don't know till date.
You challenge that rule.
2005 Act,
I am asking you, did you challenge that rule?
rule I
That-
did not, rule I did not.
So you
But
can't argue.
my
Now-
submission would be, the rule framed by the government has not been given effect to.
Correct. So rule says 5 members, which includes panchayat nominee. They will judge your caliber, knowledge,
Today, my lord, it has been,
expertise. Now they have awarded separate marks. What do you want? How that marks is to be taken by this election? How? By a majority?
by a
That-
majority.
That out of 5, if 3 have given a higher marks, then those whose 3 marks should be taken as a bet, or as a I would say the factor to take the total marks, and 2 to be ignored. This is what you wanted to say.
This is one aspect of the matter, my lord.
No, this is the only aspect I'm asking.
No, your lordship.
Then I will go. I will go later on. This is what you wanted to say.
This is one of the aspects. I want that. I wanted that, my lord. This is one of the aspects. Other aspect is, my lord, what is the qualification the panchayat nominee possess?
Now,
2005 Act
is
did no
there-
reply.
please, is there any, I'm coming one by
Fine,
one.
fine.
Is there any stipulation in the rule that a person who shall be the member of the selection committee
President of the government.
must possess this qualification?
He has become a
There is
president
rule.
of the
I'm
selection
asking
committee.
you, is there
Your
any
lordship.
rule? Is there that minimum qualification one member or every member of the selection committee must possess? Tell us.
But your lordship kindly, this is one aspect of the
in a
matter. Other
diverse-
aspect is, my lord, whether
Diversity, which is a very unique feature, or would say the best, I would say the precious possession of our country. Every person who may not have a formal education, but is very intelligent and knowledgeable.
now presently, my lord, this school has become, my lord, sponsored school, government sponsored school, and now notification says that
Can you say anything to be done by an authority which is not provided in the rule? You can't.
no, my lord, now what has happened, my lord?
Now what?
Sponsored school, my lord, every members would be, my lord, would possess, my lord, graduation.
This sponsored school, this sponsorship was granted when?
My lord, that has already completed
When?
2014 onward.
Onwards. And when this selection process was undertaken?
And thereafter, my lord,
When this selection process was undertaken or initiated?
but I am told by my client that that has been already, my lord,
I am asking you, the selection process was initiated when?
but দেখো তো এটা কোথায়? But your lordship kindly have to the notification of the government.
I am asking you, madam, please, this assistant headmasters, the post to be filled up when it is started. When the selection process was initiated.
2018. 11th January 2018.
I just want that. Where is the notification which says that this rule was amended? The rule
That is
which
not,
is
my lord, that is
quoted,
not with
memo
him, my lord.
dated 1628 was amended.
That is not in respect of sponsor school, my lord. In respect of sponsor school, government sponsor school, that has now, my lord, changed. Minimum graduation certificate would be with them.
What?
Would be the member of the selection committee.
I am asking you whether this rule was amended.
But actually, my lord, that notification is not with me. I can, my lord, collect it, my lord.
What collected?
The notification of the government.
What
Graduate certificate must be there with the members of the selection committee. Minimum.
Have you pleaded that in your writ petition?
At that time, my lord, I was not informed that that was the government sponsored school.
So, have you pleaded here in the stay application?
I pleaded that the rule in existence has not been complied.
That's a too vague a term. And the rule in existence is found to be a memo dated, memo number 1628. Where is the memo number 1628? Which page? Oh, do you have an extra copy?
Yes.
Yes.
এটা কি দিলেন?
You have the
160.
another set
Oh,
of
one
copies.
sixty. I have annexed.
I'll just.
I have annexed with my petition, your lordship.
Which page?
Which is in vogue, my lord. Was in vogue at that time. I have annexed that.
That is writ petition আছে page 35. Can you put page 35 of the writ petition? Writ petition is no. I'll help.
Page 35. Oh, এখানে
Another copy in the writ petition is there.
The candidate school. It's aided institute.
Aided institute.
Aided, that's what
Yes.
I said, aided.
Aided.
Candidate school.
ঠিক আছে। Petitionটা বার কর, তাহলে petitionটা বার কর।
I have not challenged this.
My yes.
You have not challenged it.
Yes, I have annexed it, your lordship.
You have not challenged there that it is ultra virus.
No.
No, I have brought it to the notice of the Honorable Court that that rule which was in vogue at that time has not been, my lord, complied with.
Rule of 2002.
Yes.
And it is a process of 2018.
My lord.
So it must be invoked.
At that time it was.
Tell me that it has been superseded. And when superseded, show us.
the process is of 2017, not of 18.
2017.
17.
So whether this was invoked or it was superseded by another rule.
No, they've not said that at all.
Illegal.
That's not in the writ petition.
No, not in the writ petition part.
And they've not said that also.
The point of law, my lord, your lordship, even if I did not take it.
It's not in the month of March 2018.
Basic party.
Yes, madam.
My lord, petitioner was, my lord, at that petition appellant period, lordship, my lord, he possessed highest qualification and awarded 29 marks. My lord. It was in respect of the academic qualification. That particular experience, my lord, he is the highest, my lord, possessing highest experience 11 years, and other who have been put in 1 and 2 in serial in the panel, they were, my lord, much, my lord, junior to the petitioner imperial lordship. This was the point taken by my client. That apart, my lord, your lordship will find from the said notification 10th July 2002, my lord. My lord, your lordship kindly have a look to my lord, ABC, 5 ABC. I shall place, my lord. Page 74, your lordship will find my learned senior friend already, my lord, handed over your lordship.
Yes.
See, your lordship kindly have a look to. The selection committee shall select candidate in the following manner. Academic qualification, including professional qualification, 30 marks. Experience, 5 marks. For experience, 5 years. But less than 10 years, 2 marks. But now your lordship kindly have a look to. The regulation says that at paragraph 3A, thereafter, your lordship, 3. One teacher's representative to be selected by the managing committee In case of government sponsored school, where there is no teachers representative in the managing committee, one of the sponsored assistant teacher, approved assistant teacher of the school to be selected by the managing committee. The school having administrator at the committee, the representatives shall be selected by the teaching staff. So this is the rule, that one of the member of the selection committee teachers representative and will be selected, not elected. In this case, your lordship will find from the resolution, 2 members contested this and one of them had been elected. So this is in violation of this process which was laid down by the government. They have not complied with that. Managing committee, my lord. So, my lord, this is, my lord, according to my submission is concerned, this is not, my lord, permissible under the law, as government already laid down this, it is binding upon all the schools, my lord, but that has not been followed. This is one aspect of the matter. Secondly, my lord, the members of the selection committee, 2 members, I am not, teachers representative was not selected but elected. This is one point. Secondly, my lord, the other, my lord, the Panchayat nominee, who has been, my lord, who has become, my lord, already at that time, he was a member. Later on, when the selection was going on, he has become a president of the said managing committee. All the experts are there, but Panchayat nominee was selected as president of the selection committee, and he awarded 1.5 mark, and who the elected teachers representative, he also same 4 identical marks. So, the distinct bias is apparently appears from the allotment of marks by the 2 members of the selection committee, whereas the experts as well as who are the designated person, they have awarded this mark. Now, I shall, my lord.
Yes.
Lord, your lordship kindly come to page 89.
এখান থেকে পরের থেকে এই চেম্বারে
I'm sorry, my lord.